So before we get started, I just wanted to let you know that we are recording. If you have any concerns about that, please let us know. Just gonna open up our presentation. And start sharing. Before we get started, I just wanted to give a couple of notes about our expectations for the meeting. One is that we ask that when you're not speaking to please mute yourself. And then the second is that we'd like to ask that if you have any questions that you put them in the chat. That will enable us to respond to your questions at the end of the session. We hope we'll get to all of your questions. If we don't, we'll be emailing them answers to them, or if they're questions that we don't have the immediate answer for, we will send them. The last note I wanted to make was on language. I'm going to be reading a quote from a previously incarcerated activist named Eddie Ellis. He wrote a piece called "An Open Letter to Our Friends on the Question of Language." And I'm just sharing this to give a sense of some of the—
I don't want to join my Zoom until we finish.
Is that okay?
I'm sorry, can you mute yourself, please? About the language that Nancy and I will be trying to use. So this is a quote again from Eddie Ellis, who is a previously incarcerated activist. When we are not called mad dogs, animals, predators, offenders, and other derogatory terms, we are referred to as inmates, convicts, prisoners, and felons, all terms devoid of humanness, which identifies us as things rather than as people. These terms are accepted as the official language of the media, law enforcement, prison industrial complex, and public policy agencies. However, they are no longer acceptable for us. We are asking everyone to stop using negative terms and to simply refer to us as people. People currently or formerly incarcerated, people on parole, people recently released from prison, people with criminal convictions, but people. And now I'll start the slideshow. Nancy Bettinger and I both serve on the Legislative Action Committee. The committee is comprised of 24 legislative specialists who are the driving force behind the state league's advocacy work. Specialists select and monitor about 150 bills in 20 broad areas, each 2-year legislative session. Specialists suggest advocacy actions that local leagues and members can take, organize educational events. Black action is contingent on state and/or national positions and policies to support activity and are guided by the League of Women Voters in Massachusetts program priorities set by convention. You can see a list of all of the bills and all of our specialists by going to the link below, which we'll be sending out in a follow-up email. How do we decide which bills to propose for the League of Women Voters of Massachusetts support? In our area, we take cues from criminal justice reform advocates who represent people and communities most impacted by the criminal justice system, both at the adult and juvenile justice level. To identify priorities, meaning which bills do those groups feel are most important at the moment for creating change in the system. To identify legislation, we also look for bills filed by legislators that both represent those priorities and are supported by League of Women Voters positions based on past studies. At the state level, that's those positions are detailed in where we stand, and at the national level, they are detailed in the publication impact on issues on the national level. Okay, Nancy, I'm gonna let you take over.
Okay, thank you, Lucy, and thank all of you for being here. We really appreciate it. Before we talk about specific bills, I just want to mention a couple of things about League of Women Voters positions on criminal justice. If you look through the positions that are listed in the State League of Women Voters document and in our summaries, you'll see that the League of Women Voters positions tend to emphasize rehabilitation, shorter sentences, humane conditions in prison, and support for reentry into society. And that contrasts with our current correctional system, unfortunately, which tends to emphasize very long sentences. Long sentences are handed down in our justice system, and punishment, an environment of punishment, and very light on rehabilitation. And you'll see this reflected, I think, as we go along and describe some of the bills that we're promoting and the reasons why they're important. Next slide. Another thing I wanted to mention is that racial disparities really are prevalent throughout the criminal justice system in Massachusetts. And fortunately, the League of Women Voters US has published a very strong statement against systemic racism in general, and particularly strong statement against systemic racism in the justice system. And so this resolution from the National League plus our State League positions on criminal justice combined really give us strong support for the bills that we want to advocate for in the legislature. Next slide. We're going to be talking about 3 bills today. The first is on solitary confinement. The second is on expanding the age range that's covered by the juvenile justice system. And the third is related to parole eligibility. So next slide, Lucy. So I'm going to talk about the solitary confinement bill first. And you might notice that the bill itself uses the term segregated confinement, but I'm going to keep using the word solitary because I just think it's more familiar to more people. So in short, what this bill does is reduce the damage that's done to incarcerated people when they're placed in solitary confinement. And it calls for more humane treatment and living conditions in solitary confinement. More specifically, it reduces the number of people placed in solitary, the length of sentences, prohibits some of the most vulnerable people from being placed in solitary confinement that are still allowed to be placed there, prevents long-term placement of mentally ill people, and generally requires more humane conditions and meeting basic needs. And there's a long list of changes that it would require, too long to mention here. It also ensures that visitation privileges are continued, or at least it limits the extent to which they can be discontinued while someone's in solitary. And finally, last but not least, it requires a collection of data on solitary confinement sentences for different groups, racial data and data on LGBTQ people, so that we can evaluate whether there are disparities and discrimination in placing those people in solitary. And there have been reports that that's been a big problem. Next slide, please.
Sorry.
It's okay. So why is this bill important? I think the central issue here is the fact that isolation and solitary confinement really damages mental and physical health of people who are placed in solitary confinement. And some of the psychological effects that it has include decreased impulse control, paranoia, post-traumatic stress disorder, self-harm, suicide, and psychosis. And some of these persist long after the confinement is over. And this is really the reason that a number of rights groups and advocacy groups have identified solitary confinement as torture. For example, the UN has said for a long time that solitary confinement after 15 days may constitute torture in some cases. And there are other groups that have said things along the same theme, not always using the word torture. But no matter what we call it, and no matter what the time period is that it takes to have these awful effects, one thing is clear, and that is in Massachusetts, our system of keeping people in solitary for months and even years is way beyond the point of cruel. I mean, at least we have to call it cruel and inhuman treatment, if not torture. Personally, I think it's torture. But as bad as these health effects are, there are other effects of solitary confinement that we've been considering. One is it's used for mental health watch, which is kind of a contradiction, because people are put in solitary confinement conditions supposedly for their own protection, people who are in mental health crisis, even though we know that solitary confinement actually increases mental health effects, actually makes them worse. And then a couple of other things. Solitary confinement disrupts rehabilitation. Sometimes people spend so much time in solitary, they end up being discharged to the general public without really enough programming to prepare them to be successful. And then finally, it breaks family relations and community connections. And that's really, really difficult, because it not having communication with family or anybody really in solitary confinement, there's no communication, no meaningful human interaction with anybody. And that again has really bad effects on people's psychology. And the other half of this is that the families become disconnected with their loved ones. They don't, they might know they're in solitary, but they don't know what's happening to them or when they're going to get out necessarily. And it's very stressful for everybody. So next slide, Lucy. So this just puts this bill in context a little bit. In 2018, the Criminal Justice Reform Act passed a number of reforms and changes to solitary confinement. It defined solitary as restrictive housing, and it defined it as greater than 22 hours a day. But then shortly after that, the Massachusetts Department of Corrections created a different category called secure adjustment units. And they were supposed to be for 21 hours a day. And so then they asserted that for these units, those reforms didn't apply because these units weren't restrictive housing and they weren't 22 hours a day. So it was really kind of a cynical move, I think. So now we have this new bill in 2021 that includes a lot of reforms that were intended in 2018, but not implemented. And in this case, it's trying to be sort of loophole proof and to really make changes that are needed in the harsh conditions in solitary once and for all. So next slide. Our Department of Corrections has found itself in the spotlight, unfortunately, recently in a number of cases. One important report that came out was by the United States Department of Justice, and they issued a really scathing report on our Department of Corrections, criticizing how they used solitary confinement for mental health watch and the damage that it was doing to people. Another report that came out more recently is called the Falcon Report, and that was commissioned by the Department of Corrections itself to review their practices and make recommendations. And the Falcon Report recommended eliminated restrictive housing and called for a shift in the philosophy toward rehabilitation, called for Department of Corrections to put more emphasis on rehabilitation. And then the last thing I want to mention on this list is a Globe Spotlight report, which many of you probably saw. It really talked about the excessive use of force in an incident in January 2020, where the corrections officers took two men that they suspected of something and put them in a cell that was out of sight of the cameras and proceeded basically to assault them and threaten them with guard dogs and basically terrorize them. And this is not an incident that happened in solitary, but it's of concern for solitary because first of all, it sort of highlights the culture of cruelty that we see in some parts of the Department of Corrections. And in addition to that, it sort of shows the abuse that can be perpetrated when people are out of sight of the cameras. And that's a concern for solitary, because when you're in solitary, you're not in sight of cameras. So next slide. Okay. So then recently, actually in June, not July, the Department of Corrections announced the intention to eliminate solitary confinement in Massachusetts, actually eliminate restrictive housing. And a lot of people thought, well, great. You know, it sounded like solitary was at an end and we don't need to worry about it anymore, but that really is not the case. Because only restrictive housing was really spoken of, not this other category that they've created or any other categories that they may create. The implementation timeline is about 3 years or longer, and really no specific reforms have been proposed. So the proposed legislation that we're talking about is still necessary because the use of isolation really has to be curtailed. And the Department of Corrections operations really still need a lot of oversight. And just one more thing I want to mention on this. I think as citizens responsible for what our government does and how it operates, I think that we have to admit that we're all really supporting these harmful practices, and we need to do whatever we can to stop them. And so when we send out action alerts later on in the year, asking you to contact your legislators and about this bill, I hope a lot of you will respond. I hope all of you will respond, because we really need all of your voices on this. And so Lucy, I'll turn it over to you.
Great, thank you, Nancy. I'm going to be talking about Raise the Age bill. So what does this bill do? So it raises the age of juvenile justice system jurisdiction from 18 to 20 for 18 to 20 years old to be included, and it's gradual over a 5-year period. If enacted, this would include 18 to 20 year old people in the juvenile justice system, or divert them into community-based criminal justice system programs. Please note, this doesn't change statutes pertaining to the prosecution and sentencing of youth and young adults charged with most serious offenses, such as first or second degree murder, which are automatically tried and sentenced in adult or adult superior court. Additionally, there will still be the opportunity for folks who are tried in the juvenile system to receive adult sentences in adult correction systems for more serious offenses. So what is the problem? Why is this bill being proposed? Young adults aged 18 to 24 are the most likely demographic to find their way into Massachusetts prisons, and they are the quickest to return upon release. They have young adults, which you may also hear me refer to as emerging adults, have one of the highest recidivism rates of any age group that engage with the criminal justice system. Young adults spend 10 to 20 times more time incarcerated in houses of correction than any other age group. They also have the highest recidivism rate of any in the adult system, with 76% rearranged within 3 years. There's also tremendous racial disparities between white and Black and Latino or Latinx young adults. Black young adults are 3 times as likely to be imprisoned as their white peers, and Latino or Latinx young adults are 1.7 times as likely to be imprisoned as their white peers. One of the main things that has been found in research is that being involved in the adult criminal system versus the juvenile justice system creates significant barriers to accessing education, gaining employment, and securing housing. So there's significant collateral damage and collateral consequences, that come from being involved with the adult criminal justice system. So I'm going to talk a little bit about what makes the juvenile justice system different. And so I'm going to be using a resource that's not in the presentation. So let me stop sharing for a moment. I also just wanted to take a moment to say thank you for understanding that we're not going to address comments in the chat, but at the end, we'd be happy to address comments and your questions. So feel free to enter questions at any time, and then comments we'd like to ask people to say verbally during the Q&A, just so that everyone can hear the tone of voice when you're making a comment. Thank you. Why is this a good idea? Or why is this being proposed as a good idea? Neuroscience has really shown that the adult brain doesn't fully develop until later in someone's 20s, mid-20s. And this emerging adult group, 18 to 20-year-olds in a kind of normative development process has higher rates of impulsivity and also higher rates of being susceptible to peer influence. One thing to keep in mind is that significant numbers of young adults who are engaged in the criminal, who have contact with the criminal justice system at different stages, have layers on top of that kind of normative young adult experience of trauma, and other adverse childhood experiences, including poverty, violence in the home, parents who are incarcerated, substance use, and other traumatic experiences or adverse childhood experiences. Folks who have those experiences are more likely to be engaged with the criminal justice system at a younger age. It doesn't mean everyone who has trauma or adverse childhood experiences is going to be engaged. It just means the likelihood is stronger. So that's one reason that we are finding that we're failing emerging adults, is that we're not taking into account that that brain science and where people are developmentally. So I'm going to share now, if it works, another resource. Let me just. So one thing I wanted to explain really quickly is what I mean by the juvenile justice system, that it's not just one stage. So for example, there's the arrest stage, which is when someone is taken into custody by a police officer, and a police officer can also give you the summons to appear at juvenile court. Then the court system is a separate system, and there's when there's in court, there's kind of a different type of sentencing available. And at these stages also, there are more diversion programs available to help folks. So there's a difference in the charging, and that can be done. And there can also be the opportunity that youth can excuse me, be released or detained. After, when someone is sentenced, they might receive commitment to a correctional facility, which again could be in the Department of Youth Services, or I'm sorry, I'm saying so much, or they might receive probation or a diversion sentence. And then post-commitment services. So another reason that the bill talks about having youth, young adults, excuse me, engaged with the juvenile justice system is that after youth are complete their sentence, they can continue to receive DYS services. So one thing to keep in mind is that the Department of Youth Services, although right now the age is up to including 17-year-olds, they're already working with young adults who are 18 to 20 years old, both in terms of people currently serving their sentences and in their post-commitment services. So they have experience with doing that. And I apologize, I'm just gonna, okay. Okay. Can one of the co-presenters tell me if you can see the other slide that says what makes the juvenile justice system different?
Yes.
Okay, thank you. So this, I talked about how the juvenile justice system has greater opportunities for formal diversion and alternatives to actual arrest for low-level offenses. It also provides some legal protections that currently are not as available in the adult criminal justice system. At the federal and state level, there are mandates to reduce racial and ethnic disparities. There's not those same mandates in the adult system. And there are also model regulations in the Department of Youth Services to protect LGBTQ youth, which also are overrepresented in both the adult criminal justice system and the juvenile justice system. There also are some special protections during arrest and confinement, confinement meaning jail before being sentenced to more long-term confinement in a DYS program. The primary emphasis on a lot of the DYS programming is on education and programming. People are required to attend school. Families also have to engage, so there's a way for parents to be involved. Again, research has shown for emerging adults that having, I'm sorry, Patty, did you need to say something? Oh, okay, that having those positive social ties, particularly with caring adults, is extremely helpful to better outcomes for emerging adults. Department of Youth Services has banned the use of solitary confinement or segregated housing since 2013. Young people in adult prisons disproportionately end up in solitary in adult facilities. As we mentioned, there are fewer collateral consequences. Juvenile proceedings are confidential, and many juvenile records do not appear on a query check. And again, a juvenile adjudication versus an adult conviction does not have the same collateral context. So this, I think, the lower recidivism rate is one thing that I wanted to make sure to emphasize. So young people who've been incarcerated in the young adult system recidivate at more than double the rate of similar youth, meaning similar aged youth who are exiting the DYS system. Given that I believe it's over 90% of people who enter the criminal justice system will someday be released back into the community, I think making sure that people can return to the community and contribute in a positive way and have a less future criminal activity and involvement is a plus for all of our communities. Last, Massachusetts has seen a 51% reduction in juvenile crime rates since they raised the age to include 17-year-olds for juvenile justice. So it's been So we've seen the advantages to including more young people in the system. So I'm going to stop there and turn it back over to Nancy. All right, go back to our presentation. Thanks for your patience with all of our technology challenges. Okay, Nancy, go ahead.
Nancy, can you unmute yourself?
So sorry. Okay, now I'm going to talk about the parole eligibility bill. What this bill does is give all incarcerated people the opportunity for a parole hearing after 25 years of whatever sentence they have has been served. And so that means eligibility, that means the opportunity to be heard. It does not mean that they're necessarily going to be released on parole. And this includes people who are sentenced to life without parole. So it means it essentially ends life without parole because it means that people can have a hearing after 25 years. And again, it doesn't mean they're going to be allowed out. It just means that they can have a hearing. And the other thing this bill does is lay the groundwork for restorative justice programs. Now, the focus of advocacy around this bill is really on the life without parole component and really essentially truncating that. And so that's going to be the focus of what I'm going to say. I'm really going to be focusing on life without parole and why this bill is important to pass, and it's important to give everybody an opportunity for a parole hearing. Next, Lucy. So why is this bill important? Since we don't have the death penalty in Massachusetts, life without parole is the harshest punishment that in the state. It basically means that the sentence means that the person is going to be in prison until they die. And most people think that that sentence is reserved for the most serious crimes, which makes sense, it should be, but it is not. People are under that sentence for different reasons, some because of the number of offenses that they have on their record, and some because they were involved in a situation where someone killed someone. They weren't the person that killed someone, but they were there, and so they're sentenced to life without parole. And so what that means is that our sentencing system is really not proportional. We really don't have proportionality in our system, and that's a big problem. Another issue is that sentencing someone to life without parole denies that they have the capacity to change, and people do change. And many people who have been sent to prison for doing really pretty awful things actually change in prison. It also reduces the incentive for participating in rehabilitative programs. And importantly, these sentences, when these are used heavily in a state like ours, they do not lower the crime rate in the state. There have been studies that compare different states, and the ones that have the highest use of life without parole do not have lower crime rates. And studies have also been done to show that they do not deter crime, but they do contribute to the aging prison population, which is actually quite expensive. Okay, next slide. Another problem that I should mention with these life without parole sentences is that really there are a lot of league positions that are really contrary to these long sentences and not giving people a chance at rehabilitation. So life without parole sentences are really overused in Massachusetts. They're actually overused across the country, but Massachusetts is one of the highest users. And I took a look at the comparison of the LWOP sentences being served in our state, and this is 2020 data, and figured out on a population basis how many LWOP sentences per billion people were given. And our state is pretty much far and above all of the other New England states and our neighboring states of New York and Connecticut. So we really are in the realm of heavily overusing these long sentences. Next slide, Lucy. So the issues around this bill are actually quite difficult because people have fairly strong feelings about, many people have fairly strong feelings about LWOP sentences, and when someone gets sentenced for doing a really bad thing to LWOP, that should be the end of it. And so it's a difficult, sort of a difficult dialogue. And there are differences of opinion on, whether we should be focusing more on rehabilitation and less on these long sentences, or more on punishment. And right now, I would say that we're way out of balance. We focus more on punishment and long crimes, and I'm sorry, long sentences. And this has a lot to do with tough on crime policies, and the desire for zero risk of error, the political desire for zero risk of letting someone out of prison who might commit another crime that's really bad. So there are a number of forces in play really giving weight to these long punishments. But I think right now we're out of balance when you look at the number of sentences that we have that are LWOP sentences, life without parole sentences, and the number of people serving them. And I think we just need to think about getting back into a better balance. I think it's difficult to say where exactly the correct balance is between punishment and rehabilitation. They're both components of our system. They're both important functions of our system. But right now, I just think that we have the wrong mix. And that's what this bill is saying. And that's what this bill is doing to try to rebalance our system. And so that's the end of what I had to say. Do you want to?
So let's
leave the slide there, it doesn't matter.
So we, in terms of what you can do and actions you can take, we really need a broad spectrum of voices speaking out on these issues. We feel that, or we find that it really is important for our state legislators, policymakers, other government agencies, and the general public to know that there are many people who care about these issues in many different types of communities. So we really need your voice and your perspective to help advance criminal justice reform here in Massachusetts. We've highlighted a few actions that you can take. We'll be sending these in the follow-up email. One is that currently, and I apologize that this bullet point looks a little funny. Right now, we are working with the Massachusetts Coalition Against Solitary Confinement to seek co-sponsors for the House and Senate bills. And so with this link, you can send a letter to your state senator and state rep to either ask them to co-sponsor the bill or thank them for already supporting the bill. The link will, when you enter your information, will automatically let you know whether or not your legislators support the bill or have not yet. Another thing to be aware of is that if you are part of a faith community, you can invite your faith leader to sign on to the interfaith clergy letter opposing solitary confinement. And again, that's an interfaith clergy letter. So it represents people from many different faiths. We'd love to know if you'd like to be on our criminal justice mailing list. we also will be available later this fall to present again to local leagues. In addition to kind of following up on questions tonight and in a follow-up email, if you'd like to have a further conversation about these bills or any of the other bills that we're supporting, feel free to reach out to us at our criminal justice at LWVMA.org email address, and I'd be happy to talk to you. And we'll be, please look out for legislative action alerts, lobby days. And then another thing that you and your league may be interested in is we also sometimes volunteer in jails to help folks who are eligible to vote, who are currently in jail. And tomorrow night, just making a plug that our voting and elections specialists will be speaking, and they'll be talking a little bit about a bill to help people who are currently incarcerated to have better opportunities to vote. And finally, and again, we'll be sharing this, these are some resources on our state league webpage. And there's a reading list. We also want to just highlight a couple of documentaries. One is 13th, which examines the history of racial inequality in the US and the mass incarceration of Black Americans. It's available for free on the director's website, and it's also available on Netflix still, I believe. And then Trial 4 is a local case, and that's available on about a local case of now a young man, Sean Ellis, who was dealing with trying to prove his innocence within the criminal justice system. So I'm going to stop sharing there. And we have a little time for questions. So, okay. Okay. Jean, I'll get to your comment in a moment. I'm just going to go through the questions first. This first one I'll take, Nancy. Are Massachusetts prisons private or administered privately? The Department of Corrections, which is a state agency, administers all prisons, state facilities in Massachusetts. There are also county facilities that are administered by the sheriff's offices in different counties. Great question. Okay, great question. So Florence asks about laws to address restoration of rights for people who served their sentences or easy way to seal criminal records. Is this true? What laws do we have? So that one we'll do a little research, Florence, to give you a more detailed answer. But there is a movement to seal some type of CORI records, and also to help make sure, for example, when people are seeking housing, that they're still eligible for housing. There's also movement around employment to quote unquote ban the box, which is the box where it says if you've been convicted of a felony, to either ban that or have people have more options on how to use a CORI record to make employment decisions. But we'll send a more detailed answer. Okay, so Nancy Bettinger, I'm going to give you this one from Linda Freeman. How likely are the bills to be adopted?
Good question. You know, it feels like there's a lot of energy around the solitary confinement bill. At least there has been a lot of energy around that. And I was really hopeful about that, but I think that the Department of Corrections coming out and saying that they were going to get rid of solitary has kind of thrown a wrench in that works, because people think that they really are, and there's not going to be any more cruel isolation in the system. And I don't think that's exactly going to happen. So I think we still need this bill, but I think that, I think the intent of the announcement was to sort of take the air out of that tire. But I'm still hopeful about it. Let's see, I'll take this out, the eligibility, parole eligibility one next. This is a tough issue. because people just have different opinions about, you know, how tough we should be on crime. And those opinions are not really something that you can change with facts and figures necessarily. And so I think we really need to get across the idea that we're way out of balance. We're not talking about being light on crime or not having people be held accountable. Certainly when people commit a crime, they need to be held accountable. We need to get in a better balance. But I think it's a very difficult and a very emotional issue for a lot of people. And I think that it's important to advocate for it, because some of these bills just take a long time to, and by long time, I mean several sessions for people advocating until it really kind of gains traction and boils to the top and gains people's attention. And so I don't necessarily expect this bill to be passed this session, but I do hope that we can get enough attention on it to give it a chance of passing in the future, to be honest.
And just a note on raise the age. One of the things that the coalitions that we've been working with in juvenile justice, this bill was also introduced last session, have been looking at new ways to kind of advocate for the bill. They learned a lot in the last session and how the bill was received. One of the messages that we've heard in all of the coalitions we participate in, including the bill that kind of is working particularly on the parole eligibility bill that Nancy talked about, and the Mask Coalition, is that there really needs, again, to be broad support. That when calls come out, a lot of legislators are only hearing from certain people, and they need to hear from people on the others who hold different positions as well. So that's why we're really emphasizing trying to mobilize our membership and your networks, because that is one way that we can ensure these bills have more of a life. Martha, thank you for your question about the bill numbers, and thank you, Elizabeth, for listing them. We'll be sending out a follow-up email to everyone who registered, and we'll be including these bill numbers and the other bills that we're supporting. We highlighted 3 bills tonight that follow the kind of the 3 main themes of the legislation we're supporting, but as we mentioned earlier, we're actually supporting 9 bills. And we're happy to talk to you or your local leagues about these bills or at some of the other 6 bills that we're supporting. Kathy, Michael, I hope I pronounced that correctly. Sounds like the DOC is a cruel rogue agency with no oversight. What is the state legislature and or League of Women Voters doing to highlight this problem? So one thing that we've noticed in the last year, and Nancy mentioned this when she was discussing segregated confinement bill, is that the federal government, particularly Department of Justice, has actually been really keeping a close eye on Massachusetts. So currently the state is actually negotiating with the state around some of the things that were found in their report on the use of mental health watch. Other things like the Spotlight series on the use of force in Sousa, which is the maximum security prison here in Massachusetts, also are highlighting. Additionally, there are some commissions, such as the Commission on the Use of Solitary Confinement. What's the right word? Hopeful development is that 2 formerly incarcerated people have just been added to the commission to be able to provide advice. They are not able to vote, but we're hopeful that perhaps, I think that's the right way to say that, Nancy, correct me if I'm wrong, but they will be able to provide advice and oversight. Did you want to add anything, Nancy?
Yeah, I think I'd like to say that I don't want to paint all the people that work at DOC as bad people. I think there are a lot of people there with good intentions, but as I understand it, years ago, corrections officers were more involved in, their jobs were broader. They were more involved in rehabilitative training and so forth. And now a lot of that programming has been contracted out to outside entities, and the corrections officers are basically, as far as I can tell, being told that their job is control. That's their job, to, you know, to control these prisoners. And so that's just created a certain environment and a certain mindset that I think I think they really need a culture change. And I was glad to see actually that their consultant hit on that a little bit and said that they needed a philosophical shift toward rehabilitation. And I hope that they bring the corrections officers into that and try to change the culture across the board and make their jobs better and more satisfying jobs. One thing that I've heard is that the corrections officers, and we've heard this from people who were formerly incarcerated as well, the corrections officers are under a lot of stress. Their jobs are very stressful. And there are high rates of psychological problems and even suicide among corrections officers as well as prisoners. So I'm sorry, I said, as well as people who are incarcerated, Lucy. So the culture needs to change, but it needs leadership to do that. I don't think it can all be laid at the feet of the corrections officers who are doing some of these things that are really terrible. But I think it's just a really broad and deep problem.
Just to add, I've had the opportunity to volunteer on a regular basis in 2 state facilities, MCI Framingham and MCI Norfolk. MCI Framingham is a women's prison and MCI Norfolk is a men's prison. Definitely have interacted with different directors of treatment in those facilities to help, and family reunification unit in the Framingham prison, where there has been the desire to provide opportunities for incarcerated people to have rehabilitation and good programming. So I definitely agree that not everybody's the same. One of the other questions we got was around abolishing LWOP for emerging adults. That's a great question. So life without parole is currently, I believe for juveniles, current juveniles, has been abolished in Massachusetts. I'm not sure that we would be able to, given the current definitions, abolish LWOP just for a segment of the age range. That kind of would create a third category. And I'm not sure that the legal systems are set up to accommodate that.
Can I just jump in?
Yes,
think
please.
it's a question, and I think that should be considered, but this bill wouldn't do that. And even the Raise the Age bill, where we're talking about expanding the age range that's covered by the juvenile system, that excludes some of the most serious crimes, as I understand it, right, Lucy? And those are the ones that LWOP sentences might be handed down for. So it really, none of what we're talking about actually does that, but that doesn't mean that it's not a good idea.
Right. So I know we just have a couple minutes left. I don't know, Patty or Kathy, if there's a way to save the chat so that we can answer these questions later. Is there a way to do that?
Yes, we can do that.
Great. One of the questions was around the bill names and sponsors. And again, we'll be sharing that in the follow-up email. We want to thank you for your time and hope that hope that you'll reach out. If you had a question or comment that you weren't able to share tonight, please feel free to email us at our League of Women Voters email. And we're happy to set up phone conversations or Zoom meetings to talk about any of these bills or any of these issues in more detail. And later in the fall, we'll be available to, we presented to a few local leagues about our work, and we're happy to do that with others. So thanks for your time, and we'll be sending a recording and more information. We appreciate your patience with us tonight as we fumbled with technology.
Thank you.